months, or will grant 56 days of credit. Court will order a crime victim's assessment of $130, court costs of $325, DNA testing fee is $60, and $68 state costs. You do have the ability to appeal this sentence. Mr. Bogo's already provided you with those papers that will explain to you how to file for appeal and how to request a court-appointed lawyer if you want to do that. At this time, you are remanded to the custody of counsel. 5552, the record should reflect Mr. Green is present here in court today. If I could have counsel with your appearance.
Sierra Coke on behalf of the people.
John Bogle on behalf of Mr. Green, Your Honor, who's just executing the notice of felony. Coach.
Yes. And Mr. Green, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Bogle about that? Yes, sir. Okay. Mr. Bogle, are there any additions, deletions, or corrections to that report?
Yes, Your Honor. Going over the report with my client, he indicated that on the very first page under jail credit that that's inaccurate. He was originally arrested back on March 14th. And he said he did 3 days and then he bonded out and then went back into jail at the bond hearing because he failed to appear. And then so he figured he had 14 days in May, and then there's June, a month, and July for a total of 56 days of incarceration, not 117. And that also appears on the very next page on the PSI there, and then the second to last page. I went through it, yeah, and there's another jail credit box there, but
Okay.
otherwise it's accurate.
All right.
Your Honor, I think that sounds accurate. Mr. McFall isn't able to confirm one way or another because it was done out of county.
I know that he was out on bond for a period of time, so that makes sense to me. That he hasn't been in that entire time since March. So the court will modify PSI to reflect 56 days of credit. So anywhere where that's mentioned, correction. And you said no other corrections, Mr. Bogle?
That's correct. Scoring's accurate.
Okay. Thank you. Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, this PSI is interesting in that he talks about, the agent talks about how it's very unlikely that there's going to be any effect of this sentence because he doesn't seem to realize he has any type of problem. You look at his criminal history and it's littered with all these offenses involving alcohol. He's got several drunk drivings. He went to sobriety court program and then he had some violations there, but ultimately was successful in that. And then, he's driving around with an open intox, and he has these they're very old, but they're delivery cases that involve narcotics. I don't see how he doesn't see that this is a major problem. This was a lot of substances. His guidelines are high. I mean, he's 58 years old, but he has 8 misdemeanors and 3 felonies, and he already had delivery cases. I think middle to high end of the guidelines is appropriate. Thank you.
Thank you. Mr. Bogle, anything on behalf of your client for allocation?
Thank you, Your Honor. One thing I guess I could have mentioned, I forgot, but that wasn't in the report, but was in the lab report, is that as far as the possession, he had a .0503, so 5/100ths of a percentage of a gram, so just trace amounts. And of course, he pled to possession of 25 grams or less. So on that scale, it's not like somebody who had 8 grams or 15 grams or 20 grams. So it was not a usable amount, frankly, to do anything to anybody. But I would say that in talking to Mr. Green a few times that I have, that I think the probation agent may have misread that. Maybe up to this point that day, he didn't realize that the effect that that was having on him, but having sat in jail for 56 days, he indicated to me he's too old for this. He's older now. As prosecutor pointed out, those two drug charges, possession, he did do a substantial amount of jail time for that back when he was doing that. At any rate, he has a business. It's called the Hubbard Lake Home Improvement, which was pointed out. He's been doing that for 12 years. He's been a volunteer at the Hubbard Lake Sportsman Association for building fishery shelters for the biological team. He also sponsors some charity golf outings every year and a bobber hunt for Down syndrome people. Once a year, he works with the Hubbard Lake Home Improvement Supply Company, that supplier that he gets materials from, and they find elderly families, veterans, or people that are just in need, and they provide the materials, and then Mark and his two employees, they'll volunteer their time to help those people out. So he provides the building crew. He told me that he obviously hates to be in jail and do that jail time, and I think he's learned his lesson now. So he told me I'm just too old for this. So I think it has sunk in finally with the time in jail, and I would ask, given the low amount here of drugs involved, that maybe time served would be appropriate. Thank you.
All right, thank you, Mr. Green. Is there anything you wanted to say today?
Yeah, just to reiterate what my attorney mentioned is, yeah, the time that I've had to sit these last couple of months is, it's really sunk in and brought the shame, the disgust, the disgrace. I'm just, maybe 59 years old. I'm just getting too old for it. And I just hope the court can see that, and I can get back to my community and start doing some good.
Mr. Green, I did read through the report, so I'm familiar with all the circumstances that bring you before the court here today. There's also a lot of information in that report, I think, as the lawyers have alluded to, about your background and your history and so forth, your prior record, and just you as a person generally. I take all of that information into account, along with what the lawyers and yourself had to say here today. I agree with Mr. Vogel. I mean, the amount that was found wasn't substantial. I think the more concerning thing is all the other stuff: scales, baggies, glass tubes, measuring cups, scissors, all of that stuff is indications of delivery. Don't have that stuff if they're just having personal use amounts. So while the amount that you were found with wasn't substantial, circumstances certainly indicate at least the potential that there was distributing going on. And that's what's concerning to the court, because that's what's going on. It's allowing the substance to get into the community and for others to use it to be harmed by it. Your past record isn't great either. You've been in jail 5 prior jail sentences, 5 prior probationary sentences, and 1 prior prison sentence. So you've had lots of opportunities to realize that this is not the way you want to go. Maybe this is the time that does it based on your age and your other circumstances. I don't know. But the guidelines are 0 to 21. The court would be within the guidelines to impose a prison sentence. I don't think, based on all the circumstances, that that's warranted. But I also don't think a sentence at the low end or time served is warranted either, based on your conduct here and your past history. The court finds that a sentence in the middle of the guidelines is appropriate. You get accountable for your actions. In this case, provides for a degree of punishment and consequence to you, but also recognizes the mitigating factors that Mr. Vogel has outlined. The court is going to sentence, and I don't find that probation would be appropriate given 5 prior terms on probation. I don't think it would be in the community's interest, or frankly your interest, to do another term of probation. So the court is going to order a straight jail sentence of 12 months, or will grant 56 days of credit. Court will order a crime victim's assessment of $130, court costs of $325, DNA testing fee is $60, $68 state costs. You you have the ability to appeal this sentence. Mr. Photos, I provided you with those papers that will explain to you how to file for appeal and how to request a court-appointed lawyer if you want to do that. At this time, you are remanded to the custody of counsel. Yeah.
I can't.